From the News Channel 5 Network, this is OpenLine.
Hello, everyone. Welcome to OpenLine. Glad you are with us tonight. Tonight is a chance for you to call in and talk to an expert. These are always great shows when you can call in, talk to an expert. Tonight, we're talking to an expert you've seen before, who has been on talking about elder law. And now I define that, and I'm going to have our guests define it. But it is if you, let's say you were caring for an aging loved one. What are some of the things you should do? What things should you get in order? What should you be thinking about? How can you plan for that? Let's say it involves not an aging loved one that you're caring for now, maybe somebody in the future. As we all get older, it's stuff we should think about. So, happy to have with us Barbara McGinnis. She is joining us via Zoom from her office up there in Hendersonville. Thank you for being with us.
Thank you for having me.
And so,
I enjoy this opportunity.
I enjoy it too, and I encourage people to call in with their stories, because often their stories help people learn. We can all learn from whatever people are going through. They can ask you a question, they can learn something and share it. And there's so many things out there. But let me first start with you. I attempted to define it. How do you define elder law, elder care law?
Well, we are an estate planning and elder care law firm. Estate planning, I think, is a pretty easy concept for folks to grasp. All adults need basic estate planning. We can talk more about what that is. But the elder care law section or portion of our practice combines estate planning work with, exactly like you were talking about, the care coordination piece of managing the care of an older person. Elder law is often described as one of the few practice areas that's actually defined by the age of their client, right? I mean, we work predominantly with older adults. That's the reason I like to define the estate planning part, because you don't have to be necessarily older to benefit from our services. But we are kind of well known for our elder law work, largely because of Tim Takis and his concept model of life care planning, which is the integration of legal, personal care, and financial care. And when I say financial care, we're not trying to take the place of anyone's financial advisor or accountant. We're talking about financial care related to the scope of service that is elder care, and how do we pay for the care that we may need as we enter that elder care journey or continuum that we refer to.
Yeah, how do you pay for a nursing home, which will cost a ridiculous amount of money, thousands of dollars a month? How do you pay for having someone come in your home and care for you or a loved one as they get older?
Costs as much or more, yeah.
And so who are some typical, just in the last, let's say, couple of days, week or so, who's kind of come into your office? Who are some people that are coming into your office, and without giving away names, but what are some of the basic things they're asking?
Simple things from a young couple this morning that came in and wanted to put in place their first estate plan. They still have minor children, so it's very smart of them to do that so that they can identify and name the guardian of their minor children and have in place their powers of attorney documents and at least a simple will. And we can review their asset profile. How do they hold title to assets? What kind of changes should they make in order to avoid probate if that's a goal of theirs? So real simple things to some very complicated and interesting cases where older spouse trying to take care of their equally older spouse at home. And how do you make that work? What kind of resources are available for care? And then how do we pay for care? What's the best choices for paying for care? Options always include using your personal wealth One of the advantages of using your personal wealth, your income, and your savings, of course, is that you have maximum options that way. When you're paying privately for care, yes, it can be expensive, but it really opens the opportunities for you in terms of choices, right? Then we help people talk about, are they eligible for veterans benefits? And that happens almost daily here, when we're talking to the veteran or the surviving spouse of a veteran. What are their options and what are they available to receive? And if necessary, then people often come and want to talk about those anticipated future healthcare costs and how do we protect ourselves by planning in advance against some of the scary parts of using Medicaid or TennCare, particularly like estate recovery. How do we protect the home from future costs? That's usually what people are asking about.
How do you protect the home from future costs? And that's a serious concern, because
it is.
What you're talking about there is the state coming after your house to pay for the medical care that I guess a loved one may have gotten or you yourself may have gotten. Explain that. When would the state come for that?
So a pretty typical scenario, a married couple worried that one spouse is going to need long-term care in a nursing home. What can they do to put themselves in a better protected position than owning the house together? Most married people will own their house jointly, and that's absolutely fine for TennCare eligibility, because home ownership is not a barrier to receiving the Choices benefit. And Choices is actually the program within TennCare that helps pay for chronic care. It is when the person that received the Medicaid benefits passes away with ownership in that home. So they still were a partial owner in that home at their passing. When they're when the second spouse passes away, so both spouses have passed, one of them has a TennCare debt, and they had ownership interest in the home. That's when TennCare can actually claim. There's not a literal lien on the property like if we have a mortgage on our home. The bank has an actual lien on our property. It's recorded. It's part, you doing a title search can see it. TennCare does not actually put that type of literal lien on the property. It's a debt. It is a debt. And as a creditor, and they're listed as a super creditor in the line of probate creditors, so that when a probate estate is open, so someone's passed away and we're trying to convey title to assets through the probate process, part of that process involves getting a TennCare release, a letter from the Bureau of TennCare saying there is not a TennCare debt owed. So that is one of the primary mechanisms that TennCare is noticed that there is an estate and potentially an asset that they can claim against. So you cannot close a probate estate without submitting that type of release. And if you have a debt, obviously you're not going to get the release until the debt is paid.
How often does TennCare come and claim the house and to pay that debt?
Well, the house is probably the only asset left in an estate of someone that received benefits, because their asset cap is $2,000 of countable assets. Remember, the house is a non-countable asset while they're applying, so that's why they can have this sizable asset and still receive the Medicaid benefit. So they're not going to have a bunch of money sitting around to pay off TennCare, because they can't do that and still be eligible. The house is probably the only asset they're going to have. They can claim up to the amount that they paid out for a person. So if a person passed away with a $100,000 10-care debt, maybe the property sells for $200,000, $300,000. There's still money left over then for their heirs, for the beneficiaries of the estate. 10-care is just paid back. How often does it happen? Increasing frequency. 10-care is becoming increasingly aggressive. Though, interestingly enough, I'll tell you, I read this article today, and I believe it was on this little like blog thing that I get called Next Avenue, which is a pretty good little resource of hot topics for older adults and things that's going on. But there is actually a growing interest in new legislation that would eliminate the estate recovery portion because of the perpetuation of poverty and the association. Of course, people with using Medicaid benefits, it is a means-tested program, would have limited net worth or assets, and then this home is usually the only thing that they could pass on to the next generation, and the recovery from Medicaid. Now, Medicaid is actually administered on a state level. So even though there's federal, and this is why it was part of a federal initiative, or at least a call for federal action on this aspect of estate recovery, states are mandated by the federal government to attempt estate recovery. It is not optional any longer for states to pursue estate recovery or not. I think that's an interesting point. So perhaps if the right was returned to the state to choose estate recovery or not to attempt estate recovery, I mean, by and large, they really recoup a very small amount that they expend.
Yeah, and you're right. This would target lower income people, and it seems fairly brutal, you know. And certainly is something that people worry about a great deal. Now, what you just described, I'm fascinated that you just said, okay, so if you don't own the house when you go in to the nursing home, then they can't come back at you. So instead of, a husband and wife will own a house jointly most of the time.
Yeah.
Well, let's say the house is owned solely by the wife, and the husband goes into the nursing home, and the husband runs up a debt and dies, and they want to come. And they will never take the house from someone who's in the house. But then the wife moves on, and they would not go after that house. Is that right? Because his name was not on the house?
Right. They cannot.
So often people will give a house to their kids, and I know that you and Tim Takis don't think that's a good idea, but maybe it's a good idea to give it to your spouse. Is that what you're saying?
Yes, it is. And we do that with great frequency. The one thing about spouse transfers, it is not subject to that 5-year look back. Transfer to a child, subject to a 5-year look back. Transfer to an irrevocable trust, subject to the 5-year look back. But spouse-to-spouse transfers can actually happen at any time. It is not subject to that 5-year look back. And of course, the problem with doing it too far in advance is you don't really know who's going to be the sixth spouse, right? Most of the time you don't know who's going to be the sixth spouse, who's going to be the person that's going to go into the nursing home. It's not like you draw straws.
Well, Barbara, that's fascinating. I hadn't heard that. I didn't know that. That's very interesting. All right, we're going to take a break. That sets the table. There are all kinds of things to talk about. Wills, trusts, what we just discussed, which was quite interesting. If you want to call in, there's the number, 615-737-PLUS, 615-737-7587. Take a break. Be back right after this.